Now, the third key legal area that we're going to cover is business contracts. Simply put, a contract is a legally binding agreement between two parties that lay out the clear terms of that relationship. Contracts can prevent businesses and prevent lawsuits by clarifying the terms and the existence of those terms between two parties, so that if there is any issue down the road, it's clearly laid out what was expected of the parties, what their responsibilities were, and even how those issues are going to be resolved. Contracts also will provide the legal recourse for the parties in the event that one party breaches the contract. When issues arise either during or after the relationship, the contract will lay out the procedure to follow, which cuts down on confusion, time, and money spent on resolving these issues. Without getting ahead, there are dispute resolution mechanisms that you can put in your contracts in order to make sure that you have this simple dispute resolution process. Among them are provisions for injunctive relief, which typically are associated with the areas of a contract that have the highlighted language of irreparable harm. Another common provision you may see in your contracts that can promote quicker dispute resolution would be an arbitration clause. As a business owner, you rarely want to go through the drawn-out court system, so having these alternative dispute resolution mechanisms can be amazing for your business. Let's now explore some key areas that businesses can use contracts to protect themselves. First, you must define the scope of work. One of the most important aspects of a contract is defining the scope of work so that both parties know exactly what it is that they're supposed to do. This should include a detailed description of the deliverables, the timelines, the milestones, and any other requirements or specifications surrounding the actual duties of the job, service, or good to be provided. Defining the scope can help avoid any miscommunication or clear up any misunderstandings that can occur throughout the duration of the business relationship. The second thing you want to do in your contracts is establish payment terms. Contracts should clearly lay out the terms for payment, when those payments are to be made, for how much, how they're supposed to be made, to which bank account, what payment method. You want to make this as detailed as possible because these contracts essentially equate to dollar signs for your business. So you want to make sure that your rights to payment are memorialized in these agreements. To be more specific, this section should also include payment schedules and timelines for when payments are to be made. It should also include the penalties for late payments, as well as what happens if one party is late on their payments by a certain amount of days. It should lay out the procedure for how those payment issues are to be handled. Typically, this can mean including interest payments or having a certain deadline where if a payment isn't made, that non-paying party is to be determined in breach of the contract, which now allows the non-breaching party or the party that hadn't been paid to now pursue legal action. Establishing these terms clearly can both ensure that a business gets paid on time and to avoid any disputes that can arise when it comes to payment issues. That means that you can keep cash flowing into your business and not have to deal with these delays. The third thing you want to include in your contracts are representations and warranties. Reps and warranties are promises made by each party to the other and are generally made by both parties in an agreement and are essentially a promise of an existing fact. These often have to deal with the existence, the quality, and the functioning of a product or service. And a lot of times also include that a company has the legal authority and the ability to even enter into this contract in the first place. And depending on what the contract is, these representations and warranties should be specifically tailored. So that may be an area where you want to individually consult with a business attorney. Including these representations and warranties in your contracts will allow one business to have a legal recourse or a cause of action against the other if that representation and warranty turned out not to be true. For example, if a software company states in a representation and warranty that their software is going to be free of bugs, which they should almost never do because they really can't guarantee that, the person who purchased the software is then going to be able to have a legal cause of action against the company for breaching that representation and warranty. More specifically, that their product didn't have any bugs. The fourth thing you may want to include in your contracts are indemnification clauses. This can help protect businesses from financial liabilities that come about as a result of the other party's actions or damages caused by them. This ensures that they are not going to be held responsible for any of that other party's actions. So if the other party does something that ultimately leads the party that they harmed to sue you as the business owner, this indemnification clause would be able to kick in and would protect you and essentially say that the breaching party would have to pay to defend you. That's what indemnification means. And often you're going to see indemnification is associated with the term to be held harmless. Indemnification clauses are a little more complicated, and oftentimes business owners will be very hesitant to sign off on indemnification clauses as they are highly negotiated. The fifth thing you want to include in your contracts, and we touched upon this in the IP section, are confidentiality or NDA sections. These agreements, or including these provisions in your contract, can protect businesses from the disclosure of their sensitive information by the other party to the contract. Remember, this sensitive information includes things like company data, company trade secrets, and very importantly, which often does play out in the real world, are customer lists and customer databases that the company will own, because there's a lot of value in those customer lists. And so if a competitor or an employee were to obtain these lists, they could use those pretty substantially for their own competitive and commercial gain. Including these sections in your contracts will make sure that the other party respects your confidential information, and if they don't, the contract lays out a clear mechanism for how you can bring a lawsuit against them. With all that being said, it is crucial that you speak with or have a licensed, experienced business attorney do these contracts for you, because at the end of the day, a contract needs to actually be enforceable. And what determines that is the areas and the bodies of law that govern these contracts. So yes, while a contract can happen on a napkin between two business people at a dinner, that doesn't necessarily mean it's going to be enforceable, because some sections or provisions that you include in contracts are not going to be enforceable under the law. And a business attorney who can review or draft your contract will be able to ensure that it is actually going to be enforceable. As an attorney myself, I am highly against the use of online forms or templates that aren't actually tailored to your specific situation. Also, it comes into the issue surrounding enforceability, because you don't know that those agreements are actually going to be enforceable unless you have an expert take a look at them. Even then, if that's the best you can do, an online format or a template is going to be better than using nothing at all.